The registration of trust. Hi, I'm Darren Findling of the Probate Pro, and we're going to examine a scale form PC 610, scale for State Court Administrative Office, PC for Probate Court. This form is readily obtainable. You're welcome to contact our office. We'd be happy to give it to you free of charge. Now, as the title of this particular form states, it's a registration of trust. So when there is a trust that exists, and there is a need or a requirement to register it with the probate court, this is one of the forms you can use for purposes of getting jurisdiction over the trust. There are other ways to create jurisdiction over the trust by filing it with the probate court. But let's understand the mechanics here. With trusts in Michigan, there is no requirement for the probate court to have jurisdiction over it. In fact, the trust is often created for the purpose of being administered outside of probate court involvement. That's why a lot of people prepare estate plans with a will and a trust, so that if they fund their trust, they can avoid probate altogether. But there are times that trusts need to be registered with the probate court. There are times because for purposes of a dispute among the parties, maybe the trustee is breaching their duties, or there's a dispute about the interpretation of the trust, or maybe a dispute between the trust beneficiaries. These would be reasons that you may want to involve the probate court, and the court needs jurisdiction over the trust. And this is a process to register the trust with the probate court. Now, with all of these scale forms, they are created by various statutes and court rules. In this case, MCL 700.7209 and MCL 700.7210. These particular statutes identify both the registration of trust process and procedures in terms of registering the trust with the probate court. Because remember, a trust may contain information about how to register the trust, where it should be registered, whether it needs to be registered, which county, which state, for example, the trust would be registered in. So let's work our way through the document itself, tying in some of the statutory requirements. As you can see, though, with all of these scale forms, and whenever you're dealing with a trust administration, or if it's a dispute involving a trust, we strongly urge you to work with a skilled, competent probate lawyer, a lawyer who understands how to navigate through these probate and trust-related statutes, as well as understand the language and to litigate or resolve disputes involving a trust. It's really hard to do this on your own. Top left corner is the county upon which the probate court would be sitting. So that would be the venue for purposes of this registration. Again, the determination of that venue, as well as which state, may be contained within the trust document itself. If the document doesn't specify it, then there's a statute that gives an identification of how to determine the appropriate jurisdiction as well as venue for purposes of involving the probate court to resolve trust-related issues and disputes. The top right corner is the file number. Now, usually when you're filling out this form, there is no file number yet. So, for example, that information there where the blue rectangle is where it says file number is often left blank because when you file and register the trust and you pay the requisite filing fee, the court then assigns a case number to it, and that would be the first time that the file number would be reflected. The next area simply is in the matter of. That's the name of the trust. So often in the trust document, there's a formal name, and sometimes there's even a shortened name. But here, that would be the name of the trust. So for example, the John Doe Revocable Living Trust, dated January 1, 2021. That would be an example of what language may be contained in there. The settlor is the individual who created the trust, and the original trustee is the person, the fiduciary, responsible for administering the trust. Now, often the settlor and the original trustee are the same, but it doesn't have to be that way. Now, if you notice, where it says settlor and trustee, there's a parenthesis with an S. And that indicates, of course, that there may be more than one settlor, maybe more than one original trustee, as well as present trustees. So an identification of the settlor, the original trustee or trustees, and the present trustee or trustee. So if there's been a successor trustee from the date of the filing of this registration of trust, you'd identify that information there. Pretty straightforward with an address provided for the trustees. The next, again, pretty basic information here. The date of the trust signing, so this is on the original trust, as well as any amendments or restatements would be reflected in paragraph 4. Paragraph 5 provides that the principal place of administration of the trust is in Michigan. So that would be the jurisdictional place. So for example, if the trust identifies Michigan as the place for registration, then that's pretty straightforward. But often it's left open, and when somebody is living in different states or conducting business in different states, it can be a little confusing as to whether Michigan has jurisdiction. And again, you have to go to the statute to identify the appropriate place for jurisdictional purposes of the registration of the trust. Section 6 provides a checkbox. Under A, the terms of the trust designate the county as the place for registration. As I mentioned earlier, often within the trust document itself, there is a venue provision, meaning which county within the probate courts within Michigan is the appropriate venue. And if it's provided for within the trust, that section 6A would be checked. 6B says that 6A isn't the case, meaning that the venue isn't particularly or specifically provided within the trust document, but the principal place of administration of the trust is in the county that has been chosen here because, and then here is part of the statutory provision that identifies the venue selection for trust registration when the trust itself doesn't specifically identify the county upon which the registration should occur. The trustee's usual place of business where the records pertaining to the trust are kept is in this county at. So often that is the trustee's residence or business, and that provision would be checked. Or the trustee does not have a place of business where the records pertaining to the trust are kept, and the trustee's residence is in the county. So here, again, if the no mention within the trust about the venue, but the trustees are located in that county or are keeping their business records pertaining to the trust in that county, that can establish the appropriate venue for purposes of registering the trust for the court to then take jurisdiction and then adjudicate any issues relating to both the administration of the trust or disputes relating to the trust. 7, the trust is or is not registered elsewhere. And then, of course, you'd identify where that may be. 8, the trust is created by the will of, meaning it was created within a testamentary document, a will, and the name of that person whose last will and testament was admitted to the probate court. So imagine that there isn't a standalone separate trust document, but rather within a will of an individual, it says that upon my death, create a trust for the benefit of, for example, my child, Jane Smith, until she reaches the age of 25 years old. So this would be an example of a trust created within a last will and testament. And there isn't a separate trust itself drafted that contains all of the provisions relative to the trust. So here, the will may be admitted in another county or within the same county. And that provision under Section 8 provides a space for you to identify where that will was being admitted to probate and being administered through the probate estate for purposes of the trust that was created by that testamentary document. Section 9 speaks of an oral trust, and it provides for the person that created it, the date, and in the manner of. And that the terms of the oral trust, including the subject matter, beneficiaries, and time of performance, are referenced there. And again, this part about oral trust is a bit beyond the time I have for purposes of this video. But again, there's a provision under Section 9 in the event that an oral trust was created. And again, these are concepts that we strongly urge you to be working with legal counsel on. The bottom section, pretty straightforward, a place for the trustee's signature and address, and the attorney's information if there's an attorney involved in this particular matter. So this is the registration of trust, pretty straightforward single document form. Typically, the relevant provisions or the entire trust would be attached to the registration of trust. It would be filed with the probate court with the requisite filing fee. At the Probate Pro, we are passionate about everything probate. If you have questions about the registration of a trust or any probate or trust related issue, visit us at theprobatepro.com or call us at 1-833-PROBATE.